Good morning, Michelle.
Good morning.
How are you today?
I'm good. How are you?
Do you like that new introduction? I
just saw that.
actually have us both in there now, so there you go. So you're a star. But welcome everyone that's watching today. Here with Michelle Tesch as well. And today we want to talk about things to do with estate planning, primarily in regard to what to do in regard to superannuation, why people should look at maybe trusts as an option rather than self-employed or setting up business in a partnership. A key topic, which it's amazing how many times people come back when they're sort of going through the process with us, and it's their land's set up in a certain way, the ownership, and it's after having a conversation with them, they sit there and go, "Oh, gee, I wish we'd known this information back then. We might have bought it in a family trust, or we might have bought it, in whatever entity rather than the way they've bought it now." A topic that's dear to my heart, which is why 99% or 98% of lawyers in Australia just give cheap, cheerful wills. And I know we touched on this last week, but you can see it's top of mind for me, rather than proper testamentary trusts and taking the time to help people with proper planning, rather than just giving the cheap and easy issue. And it really that is the point, isn't it? I think we'll talk about this in a sec, but some lawyers just want to give the cheap option, and the job gets done, they're out, and but it doesn't really do the job properly. And but also what to look for when choosing a specialist lawyer rather than a general practitioner in regard to getting this stuff done. Because most of the people we deal with have got estates that are in the millions and 10 million and above. Not all, but a lot are, and that's a lot of wealth, and it's something that needs to be looked at properly rather than just going to the corner store guy. So they're the 5 things we can chat about today. Michelle, I know I could just hand over to you and you'll cover all 5 for the next 30 minutes. we'll head off. I want to start with the superannuation, Michelle. It's a big part of part of what you do when you put together the future focus, future planning report, or whatever you call it these days. But it's a big part of your future planning report. And I just want to talk about the whole situation regarding binding nominations, just not leaving a nomination at all. What happens if people don't leave a nomination? Why they might leave a nomination to their estate rather than to individuals? What happens if they give it to a spouse compared to what happens if they give it to a child who's 25 or 30 or 40 years old? That sort of thing. So do you want to just have a chat about how to best set up your nominations when you're looking at your superannuation fund? Thanks, Michelle.
Yeah, so I guess the first thing to mention is that super is not something you own in your name personally, so it can't necessarily be dealt with in your will. So we can say whatever we want in your will, but it doesn't mean your super will go to who you want it to go to. So the way that's managed is by doing what's called a binding death benefit nomination, where you nominate who will receive your benefits when you pass away. I guess one of the things to consider is you can only nominate certain people. So you can't just nominate your friend down the road or your sister. Well, you could if you're in an interdependent relationship with them, but most of the time you're not. So you need to nominate, so some of the people to cover is a spouse, a child, someone who's financially dependent on you or living in an interdependent relationship with you. One of the other options is to nominate your estate, which is called your legal personal representative, which is how then we can deal with it in your will. Sometimes I see clients and they say, well, I've nominated my cousin to do that, to take that money. And I say to them, I'm sorry, but that's not going to be a valid nomination. And they say, well, I haven't heard anything, because super funds don't say, oh, who is this person? They don't inquire about your nomination. They just take it in on face value. So
not until something goes wrong.
That's right. So you can also choose not to have a nomination, which means the trustee of the fund might decide where it goes. And the potential issues with that is it could be somebody or people you don't want it to go to. So, for example, if you've got 3 children and one has a disability, the super fund might determine that it should go to that child more so than the other 2 children, when you really wanted that child to not receive anything because they're being looked after through other ways.
Yep.
So to make it, I guess, certain, or a bit more certain, put that nomination in place.
If I can just break in there for a sec, with special needs trusts and so on, if you give a child with special needs extra money, that can interfere with the benefit from the government, can't it?
Yes, it can. So if they're receiving disability support pension or even NDIS funding, it can impact on that for sure.
And that's why people need to go and see guys like you people like you, not guys like you. Need to see people like you before they do these wills, because that's one of the key little issues, isn't it? If you start giving a child with special needs, disabled child or whatever, extra cash, all you could be doing is just prejudicing what the payments from the government are, and it's not the most effective use. Should be wasting money which could go to other children in your family or other beneficiaries.
Yeah, that's right.
So binding nominations, there used to be a 3-year thing. What's the deal with binding nominations now, Michelle? Is it different for different funds? Or?
Yeah, it is different. So there is, for a lot of them, still the 3-year. After 3 years, it lapses, so you need to do a new nomination. And again, that's not something you necessarily are reminded of by the fund. You need to set yourself a reminder to do that, or just check it regularly. But some funds now are offering binding, non-lapsing beneficiary nominations, so they won't lapse unless you make it lapse, revoke it, or change it.
Yeah, how hard is it for people to check who their nominated beneficiaries are? I've heard of stories of people who have got divorced and forgotten to go in and change their nominated beneficiary in their superannuation fund, and they get a bit of a shock when they find out someone they've paid a lot of money to already.
It depends on the fund. I've seen some that are just, on every statement it's right there written down who your nomination is, but some people have to go digging a fair way to find out, or even have to call their fund.
Yeah.
So, but it is a good idea to check, no matter how difficult it is, because it's critical to estate planning.
Yeah, and also, the difference between leaving it to a spouse or a dependent child as opposed to a mature child. There's a lot of taxation issues there.
Yes.
Just an overview in regard to that, why you don't want to do that?
Yeah, so some people don't have a choice, or they may only have adult children to leave it to. But for people who have a spouse and perhaps even minor children, there's no tax payable on that on that super. But if it goes to an adult child, there'll be tax payable. So it can make a huge difference, because some people's super is a lot these days, and it can be a massive difference.
Yeah, and where possible, you'd try and let the superannuation go to your spouse, or if you've got dependent children and so on. Normally they're, under 18 or something, but or university. If they're at university, they still count. But after that, they're going to pay tax. Who would have thought?
Yeah.
Who would have thought? Hey, one of the other issues that we've been, Michelle, you and I've been talking about lately is how you set up a business. And this is really important in regard to succession planning, in regard to, even if you've got a business and you're transferring it over to children, should the kids just set it up in their own name? Should they set up in partnership with their girlfriend, or should they set up in a family trust? That's an easy question.
Yeah, family trusts for sure. In most cases, I should say, not always. I think this comes from maybe even sometimes people just starting out, firstly, not knowing what to do, not getting proper advice, but also not expecting their business to become how as big as it becomes today. Yep. And so just thinking being a sole trader or having a partnership with your spouse or your kids or both is the way to go. But yeah, it's best just to set it up in some cases, to set it up in a trust, and then you've got your asset protection there, and also it helps with the succession. So you can just keep the trust going rather than having to deal with sole trader who takes over the business when you pass away, or if you lose capacity.
Yeah, and also there's tax implications too, isn't there? If you, if I owned a business and I passed it down to, my son or daughter or something like that, there's some way I know you can minimise the taxation implication of that. But I mean, if you just did it today, I own it. Tomorrow, I've given it to my son, for example. There is a tax implication to that, isn't there? Whereas if you just transfer the control of a trust, there's nothing changes.
Yeah, it just continues on. Yeah.
Yeah. That's kind of the main advantage, isn't it? And the asset protection and so on, creating a wall between yourself and the trust assets.
Yeah.
Which kind of, Michelle, brings us on to the purchase of land, and this is a topic that many times when I do workshops with Tom or others, one of the issues that's raised, and people seem to have most questions about, is in regard to how should they buy land. Now, but we're not talking about the family home here, which has certain tax advantages and so on for primary principal place of residence. But if someone's buying a new block of land for business or a new property, sheep property, cattle farm, whatever, what are the sort of thoughts that you have regarding how they should purchase that in their own name? Once again, partnership, which tends to have happened in the past all the time, or company or trust. Do you want to just go through the things people might want to think about?
Yeah, so I guess firstly the options would be to buy it in your trust, and also to buy it with you and, say, your partner, which can be held in two different ways as joint tenants, which is commonly how you would hold the family home, which is where it passes automatically to the survivor of you if you pass away. The other option, if you're holding it jointly with somebody, is to hold it as joint tenants, which is where you can hold it in certain shares, say 50-50 shares, or it could even be...
Tenants in common, you meant?
Common, yes, tenants in common. Or it could even be, say, 99 out of 100 and 1 out of 100 for 1%.
Yeah, so tenants in common doesn't just mean 50-50. You can nominate what the percentage shareholding is effectively.
Yeah. Yes, okay. That's right. So some of the things to consider is whether you want to be able to deal with your portion of the house. So let's just say you held it as 50-50 tenants in common. That means your half of the property can be dealt with in your will, rather than passing automatically to the survivor, which can still go to the survivor. But if you've done a testamentary trust will, it can go into their trust and still be owned by them, but owned by their trust for a bit of protection. It can also help with succession purposes as well. So if you want to leave that half share to somebody else other than your spouse, but allow your spouse to still use it, for example, if it's a farm, you still want them to be able to farm on it, but you want it to ultimately go to your children, then you can deal with it that way too.
Yep. So there is an issue, and I had a great question but I was listening so intently I forgot what the question was. But where was I? In regard to, let's say, a grazing property, something like that, there's different ways that people can go into owning that. Why would people normally go for a trust environment, rather than buying it in shares, in regard to protecting their other assets and so on as well? And I'll come back to that question as soon as I think of it. As soon as it catches the elevator.
Because of your asset protection, you've got, if you want to put it in that trust as well, you've got that asset protection like we talked about before with your business. But it also helps, again, with passing on succession of that property. You don't have to pass it down, and it's just changing control of the trust. So it can just form part of everything as part of that business.
Yeah. Oh, that's fine. Okay, we'll come back to that other question when it returns. Returning to consciousness near me sometime soon. One of the other issues, and we have touched on this before, but as I say, 99 times out of 100 when we run into to new clients, especially, the wills that they currently have are really not much better than a news agency will. In other words, what I call the "I love you" will. It's, I love you, honey. I'll give you. You can have all of this if I die, and I'll have it all if you die, and it's just going to be in our own individual names. So if we get sued, if we go bankrupt, if whatever, it's at risk. If we go into another relationship, it's at risk, and so on. Do you want to just explain? Because you are a lawyer. I mean, are there times when a cheap and simple will is okay, and it's sort of what asset value level, is it worthwhile investing the extra time and money to get a proper will done with, testamentary trusts and asset protection and a lot more thought going into it than just a simple will where you sort of transfer to each other and then the kids equally when you're gone. Is there a financial threshold?
Yeah, there is. So having a simple will, yes, can have value for people who have some fairly straightforward assets and no concerns.
Yep.
Everyone should have no concerns, but if you don't have any concerns about the things that testamentary trust wills protect. So let's just say the threshold is about $200,000 per beneficiary to warrant thinking about going to the expense of and doing a trust will. The issues with having a threshold, though, is that if you're, say, young to middle age, your assets and your wealth is likely to increase. So just because now your beneficiaries might only be receiving $50,000, and you just do a standard will because that's what you think is okay. And also not saying you shouldn't update your will every few years anyway, but if you don't update your will and life goes on and you've accumulated a lot of wealth, a lot of super, and you still have a standard will when you pass away, then that wealth could be quite significant going to your beneficiaries, which is then unprotected with a standard will. So although there is sort of a financial threshold, which is not a set in stone threshold, I think it's still worth considering depending on where you're at in life, what your expenses are likely to be, how much more money you're likely to make, things like that.
Yep.
But also if you've got particular concerns about one of your beneficiaries separating from a partner or things like that, things that trust wills protect, it's still worthy of consideration, at least, whether you put it in place or not. It's something that should be discussed with pretty much every single person who walks through your door to do a will, because it could still be relevant to them, even if their beneficiaries aren't receiving too much. Also for bankruptcy protection.
Sure.
If they are going to receive $50,000 in a trust and they've become bankrupt, that $50,000 is going to be they're going to be pretty happy to see that there in the trust rather than just not existing at all. So
vaporizing into thin air.
Yeah, that's right.
Yeah, and that I know Tom has told that story a number of times of a parent who definitely didn't want testamentary trusts. They just wanted to give their wealth to the son and one of their sons. And that's exactly what happened. They left a significant amount of money to a son who was just going through bankruptcy at the time. His parents passed away, and instead of having a carefree life ahead of him, it all went to the trustee in bankruptcy, and he ended up with absolutely nothing. So yeah, they're things you need to think about, obviously.
Yeah.
One of the other issues too is one of the other things, and I know you and Tom do this with clients that you deal with. You offer people 3 different types of wills, and we could play the video now that we could just have a short summary of those 3 different types of wills. And why is it that you give people those 3 options? Obviously, there's more complexity. From the initial option 1 to option 3, there's a lot of change in complexity. But what are the main things you're worried about that that people need to think about when they're choosing which sort of will they want?
So all of the trust wills we have cover off on things like bankruptcy protection, their bloodline wills. So if your child passes away unexpectedly, that trust will go to your grandchildren rather than to the surviving spouse. they all have tax planning opportunities, especially when there are minor children. The difference between the three options is the level of separation, protection you want to give your beneficiaries from separating from a current or future partner. And they're based on, a base level where there's limited protection, a medium level where there's good protection on today's laws, and then a higher level, which is sort of a bit of a future-proof protection, just for in case things change with the law, which they always do.
Yeah, they always do. So really what that's saying is, under current situations, the first and second one, you're going to be okay, but if the judges decide to get a bit more stern in regard to their interpretation of protection around testamentary trusts, the third one's going to guarantee you for a bit longer. And that's another reason why every 5 or 6 years you really need to come back, and it's like getting a car service. You need to get your will service to make sure it's kept up to date.
Health check. Yeah.
That's right. The health check. Final thing I just wanted to touch on today, Michelle, which is another one of my interesting topics, is what's the difference between specialist lawyers and general practitioners? And before you start, I always laugh when I see people who say, on their window or on their business card, and they say, "We specialise in," and they've got a list of about 20 things that they specialise in. I just think, how can you be a bloody specialist in, 10 or 20 different things? We specialise in matrimonial law and contract law and estate law and all this sort of stuff. And as soon as I see that on someone's letterhead or on their window, it's kind of like, no, they're just a general. They're a general practitioner. So I don't know how they get away as lawyers. I'm not sure how they get away with we specialise in all these things. But the difference to you, you deal with lots of other lawyers and so on. You see people in this industry. What's the most obvious thing people should look for when they're looking at getting their estate planning done? Having said that, most people who are going to be watching this are people who are going to have significant levels of wealth. How do they make sure they don't sort of get tricked into Harry, the local guy, who's he's the local guy. He's a good bloke. He plays golf. He's a member of the tennis club and all that sort of stuff. How do they make sure they go and find someone? What's your advice to help them head in the right direction?
So it's really important, as you say, to find someone who doesn't have a list of 20 areas of law they practice in. So if you choose a firm or a solicitor who only practices in one particular area, such as estate planning, then you're more likely to find somebody who's got a bit of a better knowledge about that area of law, and not just a broad knowledge about it, but also specific, up-to-date understanding and really good templates they can use, access to resources that other general practitioners may not have. So it's just, if they've got a specialist practice where they only focus on one thing, they've got much more time to focus on that thing.
Yeah,
so that's,
if that's all they're doing, they're going to be better at it. So, and it's also, what sort of associations is that lawyer? I know you guys have an association with one Australian group that do a lot of work in the estate planning area as well, and so you guys are able to share what you're doing, and other people can tell you what changes they've seen and so on as well. So it's finding someone who wants to keep growing in what they do and always be kept up to date, because it's a very one mistake in estate succession planning can be very valuable. I did a Facebook ad, and I actually looked at the video again last night. I'd done it a few months ago, but basically said it's probably about, for most of our clients, it's about 0.1% of their estate is what it costs to get their estate and succession planning done. And if they don't do that, it's going to cost, so instead of 0.1, it's going to be 2 to 3% of their estate if they don't do something. And one of the kids feels unjustly dealt with or treated, or somebody wants to have a blue with another, brother or sister or cousin or something like that. So you go from sort of 0.1% to 2 to 3%, and the lawyers, they'll say the lawyers will love you. They'll love your procrastination and the fact you didn't get around to doing it properly. So there's that, but the real cost in estate and succession planning isn't the amount of money, whether you do it before, whether you do it after. It's the relationships with all the grandchildren and the siblings, and I always hate seeing the fact that families just fall apart, and immediately mum and dad die, families fall apart, grandkids don't talk to each other, and the grandparents must be sitting there in their graves going, geez, we really screwed up on that one, because everyone's goal as a parent is always to go, you want your kids to get on, and you want your grandkids to get together, as I always say, Christmas as mates. So what I'm trying to say here, and Michelle, I hope you'd agree with this, is something that's really important, because this is what holds families together. If you do it properly, your families will hold together through the generations, and they'll be grateful for the time and effort you've put into it.
Yeah, I've definitely seen families blown apart by the passing of someone, and not because they've passed away, but because of what they've had to go through afterwards in managing that estate. So
yeah.
You're right. It is essential to keeping the family together at Christmas, as you say.
And Easter.
And Easter.
And
just generally texting on birthdays.
That's right, remembering those sort of things. Anyway, Michelle, thanks for your time again today. Great to chat with you again. I know you're very busy up there, and I'm going to see that surfboard in a different position next time.
Yeah.
We'll have one of these. I want to see it moved. I want to see you've been out on it. Anyway, thanks for your time today. Have a great day.
Thank you. You too.
See ya.
Bye.